Presenting to the Australian Homebirth Midwives Association on balancing negligence liability for private midwives. Homebirths in Australia have seen a steady increase, with planned homebirths attended by registered midwives accounting for 0.5% of births in 2021, up from 0.3% in 2019. In fact, over 60% of submissions in the 2008 National Maternity Services Review were from women supporting homebirth. The Australian College of Midwives, or ACM, supports homebirth as a safe option for women with low-risk pregnancies, highlighting in their position statement the importance of informed choice and emergency preparedness when a homebirth was attended by a registered midwife. However, it's important to note midwifery practice presents unique liability challenges, as practitioners are accountable to both mother and infant. In Queensland, midwifery is governed by the Civil Liabilities Act 2003, or the Act, and the Health Practitioner Regulation Law 2009, or the National Law. While midwives are required to maintain professional indemnity insurance under the national law, it's worth noting that currently there is no insurance available for private midwives, and this forced the federal government to launch the Midwives Insurance Scheme, or MEGA, in 2010. This scheme, however, excludes coverage for the intrapartum phase, leaving homebirth midwives without liability protection during labour and birth. This gap in coverage jeopardises the availability of homebirth services for birthing women, rendering midwives legally vulnerable and raising safety concerns for women who birth. As a result, many are turning to alternatives like doulas or free birth, further underscoring significant gaps in maternity services that are pushing some towards these riskier options where they don't have professional medical support. According to Homebirth Australia, homebirth has in fact become a casualty of a broken maternity system. And according to the Professor of Midwifery, Hannah Darlan, there are more unregistered birth workers attending home births in Australia today than there are registered midwives attending home births in Australia today. This limits the capacity and ability to monitor these people's practices, excluding them from possible penance by APRA and exposing both mothers and infants to potential risks, thereby jeopardising the overall integrity and safety of midwifery practice nationally. Now let's turn to the state of liability. Healthcare professionals, including midwives, owe a duty of care to their patients, and thus they must adhere to professional standards and exercise the expected skill and judgment to ensure the safety and well-being of both mother and child. In R.V. Barrett, the judge noted that when assessing the midwife's duty of care during the antenatal period and labour, it's essential to consider the established standard of care expected from a reasonably competent midwife. Thus, in this case, despite being unregistered, the person attending birth as they had taken on the role of midwife was held to that same professional standard of care. A breach of this duty occurs when a midwife fails to meet the expected standards of care by neglecting to take reasonable precautions against foreseeable risks of harm. This obligation requires that a midwife identifies risks they know or ought to have known, thereby ensuring that they take the steps that a reasonable practitioner would have taken in their position, making sure they take all appropriate measures to mitigate those risks. Breaches of this duty can be seen as examples in the case law as failures to obtain informed consent by not adequately communicating the risks associated with home birth. We can also see case examples where inadequate risk assessment that overlooked potential complications was also seen as a breach of this duty. Neglecting to refer patients to medical professionals when necessary. This could be a hospital transfer in the case of a home birth. Insufficient monitoring during labour, and non-adherence to established clinical guidelines. In the case of HCCC v Munro, the Commissioner found that the midwife's actions of allowing the mother to remain immersed in water during labour, despite the complications of her bleeding, constituted a breach of duty, as it was reasonably foreseeable that failing to monitor both the mother and the fetus adequately would lead to adverse outcomes. In contrast, we can see in Gunning v the State of Queensland that the midwife was found to have acted appropriately during the home birth. The harm was not reasonably foreseeable based on the clinical indicators at the time. And what these two cases highlight is that a breach of duty hinges on the foreseeability and ensuring that all clinical decisions were informed by appropriate guidelines and evidence-based practice, and and that the patient is at all times fully informed of all risks. The Boland principle stipulates that a professional is not negligent if they act in accordance with practice accepted as proper by a reasonable body of professional opinion. However, in home birth context, the ambiguity surrounding acceptable practice can lead to inconsistent interpretations and applications of the law, leaving midwives vulnerable to liability despite the adherence to established guidelines. It's worth noting that in HCCC Sheldrick, the midwife was found to have breached her duty by failing to fully inform her clients of the inherent risks associated with a planned home birth, particularly in the context of the child's breech position. I'll also note that though a breach of duty has occurred if a medical practitioner fails to inform a patient of significant risks associated with treatment, the judge in HCCC Sheldrick did want to emphasise that framing home births as merely a patient choice neglects the midwife's essential role in ensuring informed consent and communicating risks effectively. And in fact, in the case, the midwife was found to have breached her duty by failing to fully inform her clients of the inherent risks associated with planned home birth, particularly in the context of this breech position. To establish causation, the breach of duty must directly result in harm to the patient that encompasses physical injuries, economic losses, or psychological damage. The midwife's failure to adhere to guidelines, adequate risk assessment, or failure to refer must be directly linked to the adverse outcomes experienced by the woman or infant in childbirth. The challenge lies in applying the but-for test. But for the midwife's failure to adhere to the guidelines, the harm would have been avoided. And this can be particularly challenging in maternity care, where outcomes may be influenced by numerous variables, including unique circumstances of each birth, the individual health of the mother and baby, the dynamics of clinical decision-making. In the case of R.V. Barrett, the defence argued that there was no clear causal link between Barrett's actions and the deaths. In baby Tully's case, expert evidence indicated that the placental eruption likely occurred before the low fetal heart rate was detected, and transfer to the hospital may not have saved the baby. This complexity is compounded by a midwife's perception of risks, which can significantly influence their clinical judgment. Such perceptions may lead them to adopt interventions that deviate from standard practices, ultimately challenging the establishment of clear causation between adherence to guidelines and patient outcomes. This is particularly evident as midwives have noted that the inflexibility of hospital protocols hinders the achievement of normal birth, demonstrating how rigid adherence to guidelines can result in negligent care when protocols take precedence over the individual needs of the patient. We see two primary defences exist for midwives who are found to have breached their duty. Contributory negligence applies in situations when birthing woman's actions, such as disregarding medical advice or failing to follow safety guidelines, may contribute to her injury, affecting the midwife's liability. Alternatively, the defence of informed consent assesses whether the birthing woman has made an informed decision about the risks associated with home birth. The principles of informed consent require that a midwife communicate potential risks effectively, and by doing so, as midwife ACM Chief Midwife Elizabeth Predeshaka noted, fully informed consent is absolutely critical. It's about empowering women through information and, codified in the national law, highlighting the essential role of informed consent in midwifery practice. Furthermore, while midwives may assert a lack of negligence by relying on the informed consent framework, the decision of HCCC v. Michelle Sheldrick illustrates that a mere discussions of risks is inadequate if critical risks are not comprehensively communicated. This case reinforces the necessity for midwives to ensure that clients fully understand the implication of their choices, particularly concerning complex scenarios like breech presentation and prolonged labour. The legal landscape highlights a critical shortcoming. Existing frameworks may inadequately address the unique challenges facing Homebirth Midwives, raising questions regarding whether current legislation sufficiently protects homebirth practitioners while ensuring patient safety. And thus I must look to what we can do. In assessing legislative challenges, the physical, mental and spiritual safety of midwives, birthing women and their children must be prioritised so as not to result in a further increase of women practising as unregistered birth workers. It's important to note that the inflexibility of hospital protocols can hinder the achievement of normal birth. Midwives have observed that strict adherence to guidelines often results in negligent care when protocols take precedence over the individual needs of patients. Therefore, reforms that simply impose inflexible guidelines would not represent best practice. Many women view the right to birth in their own sovereignty as a fundamental human right. Consequently, legislation that seeks to regulate unregistered birth workers to align them with APRA standards is unacceptable. Instead, the best way to support home birthing women and the midwives who assess them is to create a legal framework that acknowledges their unique needs and promotes safety without imposing unnecessary restrictions. A crucial component of this framework is the development of a comprehensive insurance options tailored specifically for midwives. Currently, the lack of coverage for intrapartum phase leaves many midwives vulnerable, deterring them from providing vital support during home birth. By advocating for insurance that addresses these gaps, we empower midwives to practice confidently and to support women in making informed choices about their care. This insurance reform will not only enhance the safety and support available for birthing women, but also uphold the professional integrity of midwives. It's important that we foster an environment where midwives can fulfill their essential role without the fear of liability, ultimately contributing to safer and more positive birth experiences. Thank you.